Good afternoon to all our attendees from Asia Pacific region, and also good morning for those attending from Europe. Welcome to today's Gün Partners webinar. I'm a partner of the firm and will moderate the webinar today. We have a great panel of seasoned IP practitioners from Spain, Ms. Patricia Koch.
Hello.
And from Turkey, Ms. Mutlu Yıldırım Köse.
Hello, good morning.
Unfortunately, our other panelist, Mr. Andreas Dustman of Böhmert & Böhmert from Germany, had a small accident yesterday and will not be with us today. We just learned that he is well after a surgery. Patricia shall try to cover his part today. As we all know, nowadays humanity is living in an unprecedented times due to the COVID-19 pandemic. It has been affecting our lives in various aspects and on various degrees. Today, as IP practitioners around a virtual table, we will discuss the impacts of the pandemic on the practice of trademark law throughout the European continent. We will be covering the practice before the EU IPO, EU courts, as well as the practice within EU member states, Germany and Spain. Also, in Turkey, which is a long-term member of the EU. Indeed, Turkey, after decades of negotiations and passing various phases, starting from 60s, declared as a candidate member in 1999. Probably has broken the record of being the longest time EU member candidate state since then. Our webinar will be in conversation format and our speakers will reply to questions that I will direct to them in turn. And after the final round, there will be time for questions from the audience. We will plan on finishing the conversation part around 45 minutes. With regard to questions from the audience, you may write them through the Q&A section of the Zoom application whenever you had a question, but we are going to review and reply all of them once the webinar is completed. Before starting our conversation, I would like to introduce today's speakers. Patricia Koch-Balder. Patricia was raised in a German environment in Madrid, attending the German School of Madrid and later university, where she studied law and business administration. Thereafter, she went to Hamburg, Germany, to work in a law firm for practically 2 years, where she was assigned to the trademark department, learning about her practice of law in Germany, both in courts and at the trademark office. On her return from Germany, she joined one of the leading Spanish IP firms and specialized in IP litigation. She started as the most junior lawyer of the litigation department and ended up heading it when the former department manager was promoted to manage the whole firm. Patricia stayed there until she co-founded Balder in 2012. As a litigator, Patricia has observed the incredible development of the Spanish courts from not even understanding what a patent is. Her first hearing at the Court of First Instance in Luxembourg was quite an experience and was followed by around 1 hour to calm her stomach. She would love to be able to say that she has now got used to Luxembourg, having argued in quite a number of hearings, as she took care of all cases of her former firm in German and English, and continues to do so now. In addition to the trademarks, Patricia also loves patents, unlike many trademark lawyers. She is a strong patent litigation practice. When not working, Patricia loves to spend time with his son, Daniel, if possible on biking or hiking tours, going to the cinema, or whenever possible traveling, possible nowadays where all of us are partly locked down. Now, our other speaker, Mutlu Yıldırım Köse. Mutlu is a graduate of Istanbul University, Faculty of Law. She has been with the firm Gün Partners since 2006 and a partner since 2017. Mutlu is both a lawyer and trademark and patent attorney, specializing in intellectual property. Her practice focuses on trademarks, designs, copyrights, and unfair competition as well. She has extensive IP disputes experience and has counseled domestic and foreign clients on their IP strategies, legal disputes, licensing, and negotiation of agreements. She also supervises IP prosecution work of the firm, presents clients in oppositions and appeals regarding trademark and design applications before the Turkish Patent Office. She represents multinational, in particular from the Americas region and Asia region clients and Turkish clients from various business fields. When not working, she loves to spend time with her daughter Ela and her son Kemal Ege. Welcome, Mutlu. So after these brief introductions, I would like to start my first question. And I'm asking kindly to my panelists, starting from Patricia. Could you describe how the pandemic affected your own practice and your firm's practice, please?
Okay. Well, thank you for your kind introduction, Ugur. Well, in Spain, as many of you might know, Spain was one of the countries most affected by the pandemic. So we have had an incredible number of death people, and what the government did was just a lockdown of the whole country. So as of 15th May, Spain was simply closed. You were not allowed out of your house except for essential matters like, well, buying food and sanitary matters, and some industries were declared essential, including the legal profession. So in that sense, we were allowed to go out because we were an essential service, but still in our office, due to, well, to the risk and to maintain everyone secure, we decided to change to home office. We had the enormous luck that just the year before, due to reforms in the office, we had already worked out all the way to work from home and all the necessities and everyone was linked from home. So actually we could change from one day to the other. So on Monday, the government said that schools were closed, and as of Wednesday, we're all working from home. So that was actually very positive. We are continuing to do so. Spain is still in state of alarm, but it will finish this Sunday. But we have decided to have people continue working from home because it's working well. And why take risks when one can work perfectly from home? I mean, we have, with that, I was commenting before this all started, if we had this situation 10 years ago, we would probably have had to find some other means. But nowadays, all this digital controls and it's all so up to the well, it's just working well. You can connect from home. It's all digital. We have a paperless office, so everything was online, and in that sense, it was really not a problem to do so. And as Ugur was saying, as I'm also doing the kind of the German part because of probably this German background, and especially because Andreas is in hospital, so he can't do it right now. He also commented that they did the same thing. Germany did not lock down completely. I mean, they have always been much more free to to walk in the streets and so on. They closed schools, of course, but not much more. But also in their case, they decided to change to home office because of just risks for the people. And the more you stayed at home, the better for this, well, for getting over the confinement. So I think that kind of summarizes it. Actually, it's work from home, where that's what we did, and that's what kind of everyone in our environment did.
Thank you, Patricia. And Mutlu, what about the situation in Turkey, please?
In Turkey, the pandemic has started to show certain impacts on business life since mid-March, and we have immediately started working from home. In our office, since we have own our office management software, which includes all our files, documents, and anything that we need, it was very easy for us to change our workplace from office to our homes. At first, it was a bit complicated for everyone, but we managed to create boundaries between work life and home life. So for now, I can say that we got used to work from home. In Turkey, like the other countries, several measures and restrictions such as travel restrictions, curfews, closure of the schools, restaurants were brought into force. But as of the 1st of June, the restrictions were lifted. On June 16, the courts also started work as usual. So now we are in the new normal period, and we continue to comply with the measures. We wear masks and keep social distance. But we will see how will the new normal for us.
Okay, thank you very much, Mutlu. Now, my second question is regarding the practice in your national IP offices, trademark and patent offices, as well as for Patricia, Germany and EU also, please. Thank you.
Yes. Okay, so the situation has been quite different in all these offices. I have here a slide to share. Just let me see if I am able to share it. Okay. So I think it's working. Let's see. I think yes, it is working. So it's oh, sorry, but it's okay. That's not the one I want. This is the one I wanted. Okay, so all trademarks office throughout Europe have continues to accept applications. So they all have online systems. Actually, we have been for the last years filing electronically. In Spain, especially, the last 2 years have been a complete change of everything. So they try to have everything filed electronically, and the work done by the trademark office has been very strong, not for obviously for the pandemic, but more for day-to-day use. So we're accustomed to file online, and that has continued without problems. That has happened both in Spain, in Germany, and then the European Union, which are kind of the three offices I want to talk about today. There has been, however, a stay of the deadlines. If the parties had to reply to anything, or in some cases even appeal, but there were limitations, the deadlines were paralyzed. It was done in various phases. It was not all done. I've written here, Spain restarted deadlines on the 1st of June, but obviously that was not the first decision was not we are starting on the 1st of June. It's just, but I think it doesn't make sense that I tell you all the phases we've gone through. The European Patent Office, Trademarks Office was the same. They did it in 2 phases, but as of 18th May, all deadlines are working again. The German Trademarks Office states some cases up to 4th May, only those where the law didn't say something. So if it was a decision taken by the office that you have until you have two months to reply, then that was stayed. If it was in the law, that was not stayed. And in the European Court of Justice, they did not stay any terms. So if you had to appeal a decision of the European Trademarks Office, the deadline counted completely, but they didn't have hearings. So they're restarting the hearings now on 25th May with very important security measures, like just one entry instead of the various they had. They look at your temperature when you're going in. You don't have to use it. They don't give you ropes anymore, because there was a place where you could have a rope, so you can go to court without a rope. But in the end, they are working as usual. That they are not doing video conferences right now, but it is planned. And I've also put here a sheet. So as the FICPI, the Federation of Intellectual Property Councils, has prepared a spreadsheet where you can see all the countries, what is functioning, what is happening, is video conference possible or not. I think this is a very useful spreadsheet for anyone who has any questions about how they are working. And you can find it if you go into FICPI, F-I-C-P-I, and look for the spreadsheet on COVID. I think that's kind of the main points to say about how trademarks offices have been working in Germany, Spain, and the European Union.
Thank you, Patricia. Indeed, FICPI's resource is updated, as far as I know, weekly, and it provides great information for all countries.
Yeah. I wanted, sorry,
yes,
sorry, because I had one point that I also wanted to comment. In Spain, as we have, as the deadlines are quite complicated, Spain has prepared an Excel sheet, which I think is worth just mentioning very briefly, which is, where is it? I have it. Well, it's here. I think you can see it now, where it's an Excel sheet where you just put in the date on which the term was started. They tell you when it would have ended if there had been no stay of the deadlines, and then they say what is the real deadline. It's not binding for the office, it's just a help, so it's still worth it to look if it is correct with the law, but actually it does work very well. That's also on the webpage of the Spanish Trademarks Office. You can find this spreadsheet, which has actually been quite helpful for calculation. And then another point, which this comes from Andreas from Böhmert and Böhmert. He prepared these slides before he fell off his bike and broke the leg, where he compared the applications that have been made during the pandemic and the year before, so that we have documents to compare. And oops, sorry, that was, how do you go back? This was not the one that I wanted. Okay, now I don't know how to go back. Here. If you look at the number, I think you're seeing the slide, right? Yeah, you're seeing it. Okay. So if you look at the filings in the German Trademarks Office, you can see that, well, January and February, the pandemic was already there, but it's it's in China, it takes time and so on. It came so quickly that people should see that we are really a globalized world. But as you can see also in March, April and May, not only did the trademarks filings not go down, they even went up if you see all the years. So that is so what I have to do is go back, which is, I don't know how to, okay, here. In the European Patent Office, it was not quite that clear, but still in March they went up, but in April and May they went down, but so very little that you actually couldn't see the effect of the pandemic on trademarks filings has been really not very important. In Spain, I don't have this slide, but in Spain the filing went down by 30%. So in Spain there was an impact. As I said, I mean, Spain has had 28,000 deaths and Germany has had 8,000 with double the population. So Spain has had a sanitary crisis, which was completely unlike the one in Germany, and we have locked down everything, so the economy wasn't working. So probably that explains why they have gone down. And one thing I just, I'm sorry, but as I'm doing Germany and Spain and Europe, I hope that it's okay that I continue talking. In this trademark crisis, what the point I had put is this, I don't know, I mean, some of you as the people who hear know if it's true, but what we always say in Europe is that in Chinese, crisis is represented by danger and opportunity. I've never known if it's true, but this opportunity point is what, as you can see in the new trademark applications, if you look at the numbers, in these months, there have been 127 trademark applications, including with the word Corona. There have been 162 trademark applications, including the word COVID. So if you look at the trademark applications, I mean, there are COVID-free a lot. We have free COVID, we have word marks as well. We have, in Europe, we have always used the how do you call it? Well, the arc for the rainbow, sorry, for hope in COVID times. So they are doing these kinds of things. This Fight COVID trademark is a trademark for medical supplies. So it's all applications, we'll see. And also we have a lot with Corona. As you can see, well, there are the usual of Corona party, Corona concerts. So it seems that people are really looking forward to the new way. We have wine, we have Corona Vinus and Corona Vinus, which helps place with the wine word, which are not by the same person. So it's an idea which occurred too. And you will see here Pasta Corona, that's the only Corona trademark which has been granted in these months. But this has nothing to do with the Corona crisis, actually, because this trademark was applied for by a company which does pasta and has been doing so for a long time in Italy, and they are called Corona. So it's just a coincidence. And one of the things when we talked about these trademarks that Ugur referred to was, well, what is the matter with the Corona beer, which is kind of very famous, and well, there have been a lot of jokes about it because it's kind of who is Corona, because one of the things that came up is when this all started that the searches on Google for Corona beer went up enormously because people virus, they all looked for Corona beer instead of looking for the virus. So that is also something where I think the beer people will have to file quite a number of oppositions against all these new Corona applications.
Well, I remember reading a couple of articles discussing, you know, how this crisis, coronavirus crisis, could have affected famous Corona brand negatively. But now, you know, looking at your explanations, you know, I now think that it should have been even affected positively their business.
It could be.
So there may be some issues, you know, regarding the trademarks, but on the other side, you know, it increased its well-known status to some extent.
Well, actually, there was a news which turned out to be fake news that Corona beer had offered 15 million for people to change the name of the virus and not call it Corona. And actually, at least in Europe, we do refer to it more often as COVID than Corona. So perhaps they did have some influence on that they obtained that people didn't talk about Corona as something bad, but that we just went on to call it COVID, because certainly in Europe, people do refer to it as COVID, not Corona.
Yeah, I see in the public, they usually call it Corona, but in, you know, in business writings or, you know, official, always we call it COVID-19 as well. You're right. Thank you, Patricia, for your explanations, very useful, and the slides were very interesting. Thank you. Let's turn to Mutlu and the situation in Turkey regarding the office as well as Corona filings or COVID filings, if any. Thank you, Mutlu.
Thank you. In Turkey, the trademark office is open and active since the beginning of this period, but most of the examiners are working in shifts and some of them are working from home. Their systems were carried online a while ago and works well. Therefore, as the office is already a paperless office and has a functional e-filing system, their services are not interrupted and they were working as usual. As to deadlines, all the time limits before the office, such as oppositions, appeals, renewals, have been suspended between March 13 and June 15, and the time limits started to continue on June 16. The law also states that if there are 15 or less days for the expiry of a term as of June 15, that term will be extended for further 15 days. So we can say that even the shortest remaining time is extended until at least June 30. Due to the extensions of the deadlines, there's a delay in registration procedure since the opposition periods are expanded. But on the other hand, there's a speed in other procedures which are not subject to any official deadline, such as absolute grounds examinations, publication decisions, and decisions on the appeals. Indeed, in a webinar, the director of the office stated that their productivity increased during this period. And we can say that we feel this increase as well. For example, the office granted a decision on an appeal filed by our firm within only 10 days. So we can say that in Turkey, the office worked efficiently during this period. Like in Europe, in Turkey, there are many applications filed for the phrases including Corona, COVID-19, etc. I will show a slide and regarding the applications. Yes, this is the filings in Turkey. As you see, there are many applications, including the COVID-19, anti-corona, stay home, and COVID cleaner courses like this. And when we look at these applications, we see that many of them, especially the applications filed in classes 3, 5, and 10, and does not include any additional distinctive elements like just the COVID-19, has been rejected by the office. But on the other hand, the applications like Corona Art 19, which was filed for class 35, published by the office. So there are many applications and some of them were already rejected, but some of them has been published and they will be registered in the next days.
Thank you very much, Mutlu.
Thank you.
Now, the third round, the question is regarding the practice in the courthouses, and also how the COVID-19 crisis, COVID-19 pandemic affected the brand enforcement proceedings, including customs and criminal seizures, if available. Yes, Patricia.
Okay, well, the situation there is completely different between Spain and Germany. There is no European court with regard to infringement, so I'll just refer to these two countries. In Germany, business continued as usual. The courts made no stays, they made no differences. They have had some problems with the hearings because while they could make some video conferences, that was only possible if both parties agreed. So if one of the parties didn't want a hearing, they just wouldn't have a hearing. So, but in Germany, as you might know, there is a lot of interlocutory injunctions without hearing the other party. So those continued completely the same. So courts in Germany were doing business as usual. In Spain, the courts reacted in a completely different way. While we do have everything online, they still do a lot of work with paper. So what they did was they had it in two phases. In the first phase, they completely shut down the courts. Well, completely, almost completely. You were not even allowed to file writs with them unless you proved that the writ was COVID related or was extremely urgent. But they really put this first filter. Just to admit the writ, you had to prove why it was so urgent. So that means that interlocutory injunctions could still be granted, but they had to pass a double filter. Normal proceedings regarding infringement were completely paralyzed because that was, as it's not urgent, you were not even allowed to file writs. That was the first month. In the second month, as of 15th April until the 3rd of June, they did allow writs. They have started to issue decisions. They even judgments we have been receiving during these days, but there were no deadlines. Because all terms had been suspended, which was actually more to help the people than the court, because for the court, it is irrelevant if you have a term or not to file an appeal. But for some firms, it was not easy to give instructions or receive instructions, so they paralyzed that. And on 4th June, we restarted with everything. The courts have been functioning. It's different, of course. First, the court clerks are not all there. They are working on a way to work from home, and there is a proposal which was issued just yesterday that people with children or who are have some prior illness have to go to work physically only once a week, and they may stay for 4 weeks at home. Others is just the other way around. People who are completely healthy may request that they can stay 1 day at home, because what has been seen is that a lot of things work from home. So people just are not interrupted. No one is going to disturb them. So they have this this possibility. Right now, you're not allowed to go into a court unless you have a summons to go there. So no possibility of asking, how is my case going, and so on. That has been cancelled, because you need to show the summons at the entrance to be allowed into the building. We have no robes, which sounds kind of stupid, but it is an important difference, because, well, it's very formal. And the robe is kind of one of the signals that this is a formal matter. But as we do not have our own robes, but we take them from the bar, obviously the infection danger is very high. So they are not forced, they don't wear robes now anymore. Everything is with glass panels before the lawyer, before the judge, before everyone who is in the court room. Distance, of course, and still, even though all this, we still have to also wear the mask. So that is working now. The video conferences for in court have been tried. They cause various problems. There are some judges who do not want them, because well, you can't see the people. And one of the things someone learns when they talk to a lot of people is see how, if someone is lying or not. It helps. It's not 100% foolproof, but if you see someone, you know at least that they are not being helped, and you also sometimes get some information. So they have not done all these hearings by video conference during the pandemic. Customs has worked in theory. I mean, they have not, products were still coming into the country, but the truth is that as the commerce was just had stopped, and there, I mean, for example, the borders in Europe have exist when they have not existed for a long time. They put up all the borders. So the international commerce has been very much restricted. So even though customs has been working full speed, they have not detected as many falsifications as they usually do. If there have been some, it's more in the sanitary sector. There they have found quite a lot. That is both the case both for Germany and for Spain. Both countries are, well, an important port of entry into the European Union. Germany, because they have the second biggest port in Europe, and Spain because, well, we are kind of a peninsula, so we have ships from all over. But as the inter-communitary commerce wasn't working either, the imports have gone so much down that the seizures have also gone down. And as to criminal proceedings, they have continued. As you know, IP infringement is a crime, both in Spain and in Germany. It's not usual because, well, unless it's a falsification, it's difficult to use the criminal way, but the criminal courts have been working as well. In Spain, they, as happened in all the others, they stayed all the proceedings, except if there was a prisoner. Because if there is a prisoner, you just have to go on because you can't keep people in prison without a judge taking care of them as soon as possible. But in IP, it's not usual that you have a prisoner. It must, unless he has done it for the 5th time, they are not usually in prison while the matter is worked. So IP crimes have not been really having a serious report in court. So that's kind of the situation. So in theory, they were working. In practice, things have been quite slow.
Thank you. Thank you, Patricia. Now we turn to Mutlu to hear her observations on Turkey, the practice in Turkey. Also, in particular, I would like to hear about her experience attending a hearing yesterday after over 3 months period. Yes, Mutlu, thank you.
In Turkey, the courthouses across the country are open and active, but since March 13 until June 16, they were operating with minimum number of judges and prosecutors and personnel who are on duty. And these people gave the priority to only the urgent matters. Like the Trademark Office deadlines, the deadlines also extended for the court procedures, and all the deadlines suspended for the period between March 13 and June 15. There are a few exceptions for urgent matters. For example, deadlines for the preliminary injunction has not been extended. But while as per the law, we expect the civil courts to handle the urgent matters like the preliminary injunctions and discovery of evidence applications as a priority, there was a delay on examination of those as well. And even if a preliminary injunction decision is granted, it was very difficult to enforce the decision through the enforcement office due to the lack of sufficient personnel. On the other hand, all the hearings are also postponed after June 15. So during this period until June 16, in practice, we could still file court actions, follow up the files and file submissions through the online systems. But since the deadlines and the hearings have been postponed for 95 days, we can say that all civil court proceedings have been delayed at least 3 months. On June 16, as the guru stated, the hearings are started, and I have attended a hearing yesterday at the Bakırköy Courthouse. It was not too bad, but all people were wearing masks, so we cannot see the faces. We cannot see the face of the judge, and the judge could not see our faces. And all the people were a bit nervous, and the courthouse was very crowded. So it seems that the courts will be very busy these days and until July 20. In Turkey, after July 20, there's a break, and until the end of the August. And during this term, again, there will be no hearings, and the deadlines all will be extended. So we will start in September again.
Thank you very much, Mutlu.
Thank you.
Well, we are now coming to the last round of the questions. And before starting with my last question,
I will give about the criminal actions as well. I will give.
Oh, yes, sorry about that. I thought it's finished. Yes, thank you very much. Sorry.
Yeah. With regards to the criminal sides, during this period, it is possible to file criminal complaints based on trademark infringement and obtain search and seizure orders, as well as those are considered as urgent matters. However, the flexible working arrangement at the courthouses mean that the specialized IP judges and prosecutors are not available most of the time. And in fact, the priority of the police has shifted, and they only deal with counterfeit pharmaceuticals, masks, or cleaning products. But this week, like the hearings, the criminal actions also started to continue, and we started to conduct the raids as usual. And from now on, we will continue to fight against the counterfeiters. For the customs are indeed operative. The customs IPR recorders can be filed and approved online, and the customs continue to issue suspension decisions based on trademark infringement. The customs also continued extending the deadlines, and some customs which have never granted extension decisions before also started issuing decisions due to the pandemic. The criminal judges are more inclined to issue seizure decisions against these goods at the customs as well, as the action does not involve an actual raid action at a workplace. At last point, in Turkey, all the customs were not sending the photos of the suspended products, and we usually need to go to the customs to take the pictures. But during the COVID-19 term, several customs amended their practice, and they started to send the detailed photos to us upon our application. So we can say that it was indeed suitable time to act against the goods at the customs. So we can take the other round, Ugur.
Thank you very much, Mutlu. Thank you.
Yes.
Now, before going to the last round, I would like to remind the attendees that they can still ask questions from the Q&A panel. Indeed, we have a question, but I'll ask it in the last, after finishing this round. So in the last round, I would like to ask the speakers to comment on their predictions for the future regarding the office practices, business itself, regarding the patent office practice, and also regarding the court practices, as to how they will evolve for the rest of the 2020, and also for the possibly next year. Apparently, this pandemic will continue for a while, so I would like to hear their thoughts about this. Then, after finishing this round, we will go to the question answer section. Thank you.
Okay, well, I think the trademarks offices, both in Europe, Spain and Germany, will continue as they are. We have seen that they can work from home. I mean, they have been able to cope with what has been coming to them. So in principle, they will continue to do so. Actually, where they have found some problems, they will have the time to resolve them, because, well, we expect that at least we expect that the second wave will not come until October. So they have these months to prepare if they've seen that there have been any problems. But as I commented, I mean, both in Spain, in Germany, and in the European Trademarks Office, things have been going smoothly. They have decided, they have received all applications and are working with them as usual. There are no hearings with the only thing that has changed is that you can't have a hearing, but actually it was very unusual that you had a hearing. So we don't work with hearings in these stages. Though they are possible, they are in practice never carried out. You can't call an examiner right now, because they are still working from home, and they are not giving their home numbers, obviously. But that can also be solved, because, for example, in our office, we are using the office number, even though we're working from home. So that will be solved, because it is technically easy. But on the other hand, what you do now, if you wanted to talk to an examiner, you just write to them, and it has the same effect. So I think that the trademarks offices will try these days to solve the technical problems they might have encountered. As I told you, in Spain, there is this initiative that people are allowed to work from home even after the state of alarm finishes. So, and that will continue because, well, they've seen it's good for the environment that people don't take the car so much to go to work. So I think that will continue. As to the courts, the situation is a little different because both in Germany and Spain, the documents, the situation is very formal. We are very formal. We have very formal courts. So this idea of video conferences might work, but they still have to either change the law or have the people accept, the parties accept that it is. I am sharing a last slide that I wanted to share with you is a decision that I received from the court just 2 days ago. I think it is there now. I'm not sure. Can you see it? It's a slide. It's in Spanish, but still, oops, no, not that one. Why? This one. I hope you can see it. I'm not sure if you're seeing it. No? No? No, I don't know why. Now, yes,
now we can see
okay,
it, yes.
perfect, sorry. Well, what it shows is, well, this is a decision which was received 2 days ago. And though it's in Spanish, I think it was worth it because it refers to everything. It says that they are remaking their agendas because, as I said, all the hearings were stayed. It's due to COVID. This was a hearing I was supposed to have had on in May, and it has been changed to 22nd July, but they advised that there might be a new change. So it doesn't mean that this is final because they are all rearranging and seeing how many people come into the court and controlling that there are not too many people in the court. So that's the one thing, that they are still working with their agendas, because this one is good. It's 22nd July, but some that we have received these days post-COVID are for April next year. So they will have to find a way to recover the time, because it's a 1 year delay, which doesn't make sense. And what it says, which is very interesting, is that they are thinking of doing a video conference, but that they are implementing that technically. That means right now, they say we do not have the video conference facilities, but we're working on them. So that's the difference in Spain and Germany. In Spain, if the court says it is via video conference, unless you go to the Constitutional Court, it will be via video conference. In Germany, unless they change the laws, video conferences are not the way to do it, because both parties have to agree to a video conference. But in the end, it might be that this is the future if all the guarantees, the problem there will be more a matter of guarantees, because the parties have to, when you're in front of the judge, they know who you are talking to, they know what you're doing. Whereas if you do it from home, where you don't know if someone is telling me what to say or whatever. And that's a serious problem for court hearings, because there the immediacy, especially if there are witnesses, is very important. Some courts in Spain, for example, they have offered the lawyers to do it from home, but request that the witnesses go to court. So I think we'll see an evolution there. The groundwork is there, because we have an electronic system in court. We have everything online. All the hearings are recorded. So the technical groundwork is there, but still they have to complete the technical means that the courts have. This will be a challenge, because what is not possible is what's happening now, that we have an enormous chaos in justice. I mean, one of the things that has been done is, normally in August courts are closed. This year Spain is not closing the courts in August, because they just have to work up their whole workload. Also, given that there are bankruptcy cases in the millions, I mean, the courts are overloaded. All the labor questions are also coming to the courts. So the courts are simply blocked. So they will have to find a way to solve it. They are having now, they've already put that in place. As I said, no August holidays. They are working in the afternoons, which was not the case before, so that they can have the hearings in different hours. But while the trademarks offices are working well, the courts still have to adapt and find a way not to paralyze the legal work for the next lockdown, as it has happened this time, because it's just not bearable for the citizens. I think that's...
Thank you, Patricia. Very informative and very interesting. Thank you. And also, Mutlu, your predictions, please. Thank you very much.
First, for our office, we decided to continue working from home until September. And after September, we are planning to go to the office 1 day per week. And we are also planning to continue to work from home at least 2 or 3 days per week after the COVID-19 pandemic. So it seems that home office practice will increase for all private practice. The government agencies, such as the Trademark Office, may also be more flexible, and they may also consider working from home. For the courts in Turkey, online hearings may also be possible. Indeed, there's a draft law on it, and we expect that it may be possible in September or in next year. Finally, when we look to the impact on brands, we can predict that online interaction and e-commerce will become even more important for now and for the next years, and online counterfeiting will increase. So it will be very important for us, for the trademark lawyers and for the brand owners, to close the follow-up, the online counterfeiting, and take the actions immediately for them.
Thank you very much, Mutlu. Thank you very much, Patricia. This ends our conversation part, and we are now in the Q&A session. There is one question for both of the speakers. It is regarding this interesting, strange trademark applications that you showed us. If you could, go back and find your slides, and could you also comment how the office, your respective offices would approach such applications briefly. We may start with Patricia first. Thank you.
Okay. Well, these are the slides. I think you're seeing them, right? I'm sharing it completely. Okay. Well, I think the trademarks offices will approach them like any other trademark. I mean, there will be distinctivity issues in some of the trademarks. I mean, obviously, if you look at this COVID, for example, which is this is for cleaning services, it is suggestive, but this is not descriptive. So I don't think that there will be problems with descriptiveness. But on the other side, if you have COVID-less or COVID pass, or let alone COVID-19, which is already there, I do not think, I mean, I'm not one to prejudge what the office will do, but I do not think they will be allowed because they just lack distinctivity. I mean, you can't monopolize COVID-19 that is descriptive. So I think many of them will have problems passing the absolute grounds of refusal. Then others, there will be, well, they simply will have opposition problems. I mean, if you look, for example, at coronavirus and the other coronavirus, they are 2 months apart from different people. If the first one passes the absolute grounds, which why not? I mean, it's kind of funny, and it works with the it's a wordplay with the wine and the virus and the vinus, and it's kind of, well, but it will oppose the second one in principle. So it's improbable that both come through, but it's still too early to tell, because well, they have been filed these last months, so they have not yet been examined. I mean, all of them have been published. Some of them are already open to oppositions, not all of them. But I mean, some of them, why shouldn't they be granted? I mean, this Corona code, for example, it's a very, it's a strange trademark, because well, it has, one of the things you also, what we've seen is that many of them have been filed without a representative, and some of them don't make much sense. And I hope the Corona code applicant is not listening in, but they explain what this trademark is. It's a trademark which wants to identify the kind of contact you wish. That if you have a red corona code, you do not wish people to approach you, while when you're green, you don't mind if people approach you. But obviously that's not the trademark you would use. You would use either the red or the yellow or the green, not all of them at the same time. But on the other side, I think the trademark could be granted because, well, it is not descriptive. It's not what they want, actually. The explanation they have made is not what they have applied for, but that's a different matter. But the trademark will probably be granted. I mean, I don't see why. Of course, there is this other trademark, coronavirus. Obviously, that won't be, I mean, that should be rejected for absolute grounds. So it will be. The Trademarks Office will have more work, a lot of absolute grounds here to examine.
Yes, thank you. Thank you, Patricia, for your comments. And Mutlu, what about your comments on the trademark applications on the Turkish register?
I will share the trademarks. I think you can see now, yeah?
Yes.
Yes. In Turkey, the absolute grounds examination has been completed for all of those applications. And as we can see, the office rejected many of them, which does not include any additional distinctive phrase, and which was filed for the classes 3, 5, and 10, which are the cleaning products and the products regarding health and like this. As we can see, COVID-19 is rejected for class 10. It's an expected decision. And anti-corona, it was also rejected for class 3 and 5. But Corona Art 19, it's published, it's passed the absolute grounds examination, but it's filed for class 35. So we may expect that this application will be granted. On the other hand, stay home, it's a slogan for the COVID-19, all we know, and it is also rejected for class 3. And Coronax, it was also rejected for class 5. Anti-COVID, it was also rejected for class 5. COVID-19, we see that it's filed for the classes 1, 18, and 25, but it's still rejected. Since it's the name of the COVID-19. But anti-corona, we can see that it includes a device and the SB. So the office may think that it includes other distinctive elements. So it's published for class 3 and 5. And COVID-19, COVID-19, it also includes the redoxer. It's a distinctive phrase. It's another brand of pharmaceutical. So it's published for class 5. But COVID cleaner, as it's expected, it's rejected for class 5. And Corona also rejected for class 3. But Cortsis is published for class 9, 10, and 42. So we can say that in Turkey, the office considers the distinctiveness of the trademarks and looks the scope of the applications, whether they are related with the cleaning products or the products regarding the health.
Thank you very much, Mutlu. There is one more question for you. I have been advised that, the question is, I have been advised that any opposition filed against international trademark registration in Turkey is not notified to the trademark owner. This would cause loss of rights for owner of an international registration. Could you please confirm whether it is true? Thank you, Mutlu.
Yes, unfortunately it is true. The office does not notify the oppositions filed against the international applications. Indeed, at the last couple of months, the office started to notify some of the oppositions, but it's not a settled practice and usually does not send the oppositions and only send the decisions after the decision is rendered on an opposition. So in practice, we are monitoring our clients' international applications. When our clients inform us about the applications, when they filed applications in Turkey, we monitor the situation. And when we see an opposition is filed against this application, we inform our clients. And this is the only way for now for monitoring and following up the situation about the international applications.
Thank you very much. Let me check if there are any other questions. No, there are no questions. And we are it's almost an hour now. We are finishing our webinar. Well, I would like to thank you again for the speakers and for the attendees for your time. It was another great session, I think. We did this on Monday for Europe, Americas region, and this time for Asia Pacific. Thank you, Patricia, in particular, for your great attendance and contribution, actually double contribution of today.
Well, I listened to Andreas when he did it in the last webinar, so I had a lot of information. Plus, as you know, I'm half German, so I do know some things about German Patent Office.
Yeah, thank you. Thank you, Osmutlu. Let's say goodbye to our attendees and hope to see you soon. Thank you.
Okay,
bye-bye.
Thank you for attending. Bye-bye.